communities. We also offer opportunities for the community to learn about the residents' needs and resources for residents. Today is the first presentation of our three-part series, Rights of Residents with Legal Representation. We are asking everyone to please keep their microphone off while the speaker is presenting. If you have questions during the presentation, please type them into the chat and we will address them periodically through the presentation. I also want to mention that if you could please email Patricia Cowan if you are wanting a certificate at the end of this presentation. She's already placed her email in the chat and she'll do it again later in case it gets lost in the chat. And without further ado, I'm going to introduce today's speaker, Attorney Jennifer Roden. Jennifer Marshall Roden is a partner with Craig and Fox, PLLC in Wilmington. She is certified as an elder law attorney by the National Elder Law Foundation and is a North Carolina board certified elder law attorney. Her principal areas of practice are elder law and estate planning. Ms. Roden serves as the New Hanover County Public Guardian. She's chair of the Elder and Special Needs Law section of the North Carolina Bar Association, as well as the treasurer of the North Carolina chapter of the National Academy of Elder Law Attorneys, or as we call it, NALA. She is the past president of the New Hanover County Estate Planning Council and was the 2012-13 Borchardt Foundation Center on Law and Aging Fellow. Ms. Roden received her BA in Political Science from the University of Alabama in 2009 and her JD from the University of Alabama School of Law in 2012. And Jennifer, if you'd like to get started, thank you so much.
All right. Well, good morning, everyone. Thank you so much for joining me. I am here today to talk about powers of attorney and other less restrictive alternatives to guardianship. Often people call it a least restrictive alternatives. The statutes call it less restrictive. I've got a few objectives for today's presentation. So first, we want to really talk about what rights does a resident retain while they're living in a facility. Well, we want to talk about what decision-making rights does a resident retain if they have a legal surrogate, agent, or guardian. We're going to talk about how a resident in a facility can maintain autonomy while receiving supportive decision-making services or help from their legal surrogate or agent. Also want to talk about how a resident can avoid the appointment of a guardian of the person or guardian of the estate. And we are going to talk briefly about when a guardianship may actually be needed, because unfortunately, there are times where we're not going to be able to get away with anything other than getting a guardian appointed so that we can have decisions made for an individual. While I'm going through the presentation, it's already been shared, I do not mind being interrupted. I have small children, I'm used to it, but there's a lot to cover in this presentation, and I don't want your questions to get lost waiting till the end. So if something pops up, go ahead and type it in the chat box. They will interrupt me so that your question can be asked, and I'll make sure to answer it the best that I can. Just a little caveat, as I always do when I give presentations to folks in the community, I cannot give you legal advice based off of your specific situations. I can answer general questions, but I am always available, and my email address will be provided at the end of the presentation. So if you feel like you need to reach out to me with a question, you can. So let's talk about the important people who are involved. When we talk about an individual in a facility and decisions that need to be made, who will be involved, who may be involved, who should be involved, right? Always, first and foremost, the resident should be involved. Whether they can make decisions on their own or not, they should still participate in discussions to the best of their ability. There may be times that the family of the resident will be involved. There may be times that friends of a resident may be involved. And there might be times where powers of attorney through agents, through healthcare decisions or financial decisions will be involved. Sometimes there are guardians. Sometimes there are other fiduciaries. A fiduciary is a role that someone will serve in where they have to put the best interests of someone else first. So other fiduciary roles might be a representative payee through the Social Security Administration. It might be a VA fiduciary through the Veterans Department for someone who receives VA benefits. And sometimes elder law attorneys like me are involved. So it is not uncommon for the first time an elder law attorney gets involved when someone is either living in a facility or moving into a facility and they've never done planning before, or the family can't find their estate planning documents and they're trying to figure out how to take care of them. I also get phone calls often from nursing facilities and assisted living facilities, and even some continuing care retirement communities where they have a resident who needs some assistance and they don't really know where to start. So sometimes elder law attorneys can be helpful. So the first thing we need to talk about is capacity. So capacity is the ability to make decisions for yourself, right? Capacity and competency are two different things. Competency is actually determined by a court. So unless an individual has been adjudicated incompetent, we should always presume that that individual has capacity to make decisions regarding his or her medical or financial decisions. Unless you know that they've been adjudicated incompetent, you can't just presume they don't know what they're talking about or can't make decisions for themselves. Just because someone has a power of attorney does not mean that they can't make decisions for themselves. Powers of attorney for finances or healthcare are supportive decision-making documents. They are not intended to be a document that allows the agent to override the decisions of the principal. Individuals should always be given the opportunity to make decisions unless the medical provider who's providing the healthcare determines that that individual lacks capacity to make an informed medical decision. Maybe the other party is concerned about contracting with the individual. There's a big difference between void and voidable contracts. If someone has been adjudicated incompetent and you know it and you allow them to sign a contract, that contract is not valid. It is void. But there are also situations where an individual who has diminished capacity signs a contract and that contract is voidable, meaning we might be able to make an argument in court it shouldn't be valid. So when you're dealing with someone who you believe has capacity issues, or if a facility is dealing with someone who has capacity issues, they may have concerns about allowing the individual to sign legal documents because they're not sure if they actually understand what they're signing. And then, of course, if an individual has been adjudicated incompetent and there have been guardians appointed, those guardians make decisions unless there have been limitations placed on the guardian's power. And we'll talk about that in a little bit too. So I mentioned before diminished capacity.
Good morning, Daisy. How are you?
So what do we do when there is a resident that has diminished capacity? How do we work with that individual to make sure that they maintain some autonomy to make decisions for themselves? When that individual clearly needs assistance in making healthcare decisions or managing their finances? When do we get to the point that we cross the line from allowing an individual to make decisions, even if they're bad ones, to stripping that person of any right to make a decision for themselves? So attorneys have some guidance here. We have to follow the model rules of professional conduct, and there is a specific rule called Rule 1.14 that addresses a client of an attorney who has diminished capacity. So Rule 1.14 states that when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of them being a minor, they have a mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship. And if the lawyer reasonably believes that that client has diminished capacity and is at risk of substantial physical, financial, or other harm, unless action is taken and that client cannot act on their own, the lawyer can take reasonable and necessary protective action, including consulting with individuals that are important people in their lives, their powers of attorney, and in some cases, seeking the appointment of a guardian ad litem or contacting Adult Protective Services. So what can we learn from Rule 1.14, right? Not everybody is a lawyer, but I think that the guidance provided in Rule 1.14 can be used across the spectrum. So do what we can to treat a resident with diminished capacity the same way we would any other individual who does not have diminished capacity. And we should only take protective measures if the resident is at risk of substantial physical or financial harm or some other harm. And without action being taken, that individual could not be protected. So, that's keep that in your mind when you're working with an individual in a facility, that you shouldn't be taking steps to strip them of the ability to make their own decisions. You shouldn't be asking for guardians to be appointed. You shouldn't be turning to other individuals to make decisions for them if that individual has the ability to make a decision for themselves, or at least make the decision for themselves with some support. Guardianship should always be a last resort. You should not start here, ever. An adjudication of incompetence is done by a clerk of court. If you're not familiar with the process, you have to actually file a petition and present medical evidence at a very high standard. It's called clear, cogent, and convincing evidence to a clerk stating that an individual completely lacks the ability to make financial or healthcare decisions. And if a clerk determines that individual is incompetent, that individual pretty much loses every right that they have to make decisions for themselves. They don't get to make decisions about the management of their finances. They don't get to make decisions about what kind of health care they receive or where they live or who they socialize with. There are some exceptions, and there can be limited guardianships, and many of our clerks in North Carolina take that very seriously. But it is not uncommon for most guardianships to completely strip an individual of their right to make decisions. Guardianships are very difficult to undo. There is a process to restore someone's competency. But if you have an individual who has been adjudicated incompetent and they're living in a facility, it is incredibly difficult for them to retain legal services to help them restore their competency. It's incredibly difficult for them to have the medical evaluations that are needed to restore their competency. And there's a huge financial barrier there too. When they're not in charge of their own money anymore, how do they hire somebody to help them? And so I get these calls often from individuals in facilities, and they have been adjudicated incompetent, and they are confident they're not, right? But how do they pay me to help them? Legal aid can help sometimes with restoration of competency cases, but it's just hard. Guardianship's not always going to give the individual what they would have wanted. So it's really important that an individual's autonomy be honored and that their wishes be honored. But if an individual has difficulty speaking for themselves, they may not be able to share what they want. It may be that the clerk of court doesn't get enough evidence to show what the individual would want. And so the person or persons they choose to serve as guardian may not be the individuals that the resident would have wanted in the first place. Our statutes leave much to be imagined when it comes to who should be appointed. A priority list is you look for an individual first. If there's not an appropriate individual, we look to a corporate guardian. And if there's not a corporate guardian, we look to a disinterested public agent. I serve as the New Hanover County Public Guardian, and I should only be appointed in cases where there are not appropriate individuals to serve as guardian of the estate for someone to manage their money. But I get appointed on a lot of cases where, if you really had the opportunity to talk to the individual, they would have wanted their son or daughter to serve as that guardian of the estate, but their children maybe couldn't meet the bonding requirements that are required under statute. If they had just done a power of attorney, we wouldn't be in the same situation. So, it may not be what the person wants. A guardianship does not always solve the problem. Many counties have established multidisciplinary teams, and I'm a part of the one in New Hanover County. And one of the things we discuss often is guardianship doesn't always solve a problem. If the issue is someone is stuck in a facility or at the hospital and they need to be placed in the facility and they don't have the financial means to get there, just because you appoint a guardian of the estate doesn't magically provide funding to place that individual in a facility. And so is it necessary to seek a guardianship action if it's not going to actually provide a solution to the problem that you're facing? And then it's also incredibly important to know that our clerks of court are given a ton of discretion in a guardianship proceeding. So, we have clerks that work very hard, and they can be very overwhelmed with the amount of cases that they receive. They do not know the individuals that are brought before them for guardianship action, and they have to make the best decisions they can with the evidence that is presented to them. And often they are not given the best evidence in a guardianship proceeding, so they have to do the best they can with the discretion that they have. So again, guardianship should be that last resort. There are some new guardianship statute provisions, and they were adopted because we're trying to make it abundantly clear that guardianship should be the last thing that we consider. So one of the newest things that we have in our North Carolina guardianship statutes is the definition of less restrictive alternatives. So the definition, and please forgive me for reading it to you, but it's long, but you should hear it, right? Is an arrangement enabling a respondent, which is the person who's being adjudicated incompetent, to manage his or her affairs or to make or communicate important decisions concerning his or her person, property, and family that restricts fewer rights of the respondent than the adjudication of incompetence would and the appointment of a guardian would. The term includes supported decision-making, appropriate and available technological assistance, appointment of a representative payee, appointment of an agent by the respondent, including appointments under a power of attorney for healthcare or a power of attorney for finances. So our statutes state now that we have to entertain and review less restrictive alternatives before we ever get to an adjudication of incompetence and the appointment of a guardian. Another new part of our guardianship statutes is that respondents are now entitled to a notice of respondents' rights. It's, if you're familiar with the Patient Bill of Rights, there are a lot of rights lists out there, and now it's statutory. We actually have a form that's been developed, and when a petition is filed against an individual to have them adjudicated incompetent, they are given this notice. And the notice puts them on notice that they have the right to receive notice of all filings. They have the right to hire their own lawyer, to gather evidence, to have a hearing before a jury. They can ask that the hearing be closed, meaning no one else can participate except for the parties. They can present evidence and testimony. They can call their own witnesses, and they can question witnesses who are called. They can express their wishes regarding the rights they want to maintain and the appointment of a guardian, and they absolutely have the right to appeal a guardianship action. In some additional guardianship updated statutes, the guardian ad litem, who is the attorney appointed to represent a respondent in a guardianship action, they have a very difficult job because they're supposed to represent the individual, but they're also supposed to present to the court what they think is in the best interest of the individual who is a part of the proceeding. But the guardian ad litem now has a duty mandated by the statute that they have to explain the notice of the respondent's rights. So all those rights I mentioned before, where they actually get a form that spells all that out, our guardian ad litems now are supposed to sit down with the respondent and talk them through those rights to the best of their ability. And so, it helps the guardian ad litem shape their report to the clerk also. And the guardian ad litem can support the respondent in looking into less restrictive alternatives. The petition now also has some additional requirements that we did not have before. So if you are a petitioner in these proceedings, you have to now provide a statement identifying what less restrictive alternatives have been considered prior to seeking the adjudication of incompetence, and why those less restrictive alternatives are insufficient to meet the needs of the individual. So when preparing and filing a petition to adjudicate an individual incompetent, you have to be prepared to tell the clerk, well, we tried these other alternatives and here's why they didn't work for us. And if that petition does not contain that information, it's not a sufficient petition to bring before the clerk of court. But as I mentioned at the beginning, there are going to be times that a guardianship is probably going to be needed. Again, last resort, but they are useful. And so if a resident of a facility is incapacitated and they've never named a surrogate decision maker, so there's no powers of attorney, or if the power of attorney has resigned or they refuse to serve, and that individual no longer has the ability to sign new powers of attorney, then a guardianship might be necessary. It might be necessary if the named agents under the legal documents attempt to exercise in a manner that raises concerns from healthcare providers or financial institutions, or maybe from the Department of Social Services or Adult Protective Services, family or friends. So I do a lot of fiduciary litigation with my law partner, and it's not uncommon for us to see an agent under a power of attorney who has abused their power and they've stolen money or they have exploited the individual. Or there might be a healthcare agent who just does not seem to understand or grasp the true needs of the individual, and they're not making good decisions for them. So guardianship might be necessary then. Guardianships might also be necessary if the named agent is doing everything that they can, but there's constant interference from the resident. It doesn't happen as much for individuals who are actually living in a facility, but I see it happen often for those who still live in the community. If they have a dementia diagnosis and their capacity is very fluid, and you've probably all seen this, where in the morning they're very sharp and they know where their assets are located. They even remember the bank teller's name, but by the afternoon, they don't remember anything that happened that day. Often what will happen is that individual will go to the bank and withdraw funds and overdraw the account, or they might go close down the account and take the money, or they'll go in and change passwords or mailing addresses. And the agent who's trying to make the best decisions that they can is constantly having to go behind them and fix the problem. We also see issues where healthcare agents know that placement in a facility is appropriate, but the individual absolutely refuses to go. So sometimes a guardianship might be necessary or helpful in making sure that the individual isn't interfering with the agent being able to do their job when the individual really does truly lack the capacity to make the decisions for themselves at that point. And I don't want to step on any toes. There will be a later presentation that talks much more about what a guardian has to do once they're appointed. But just briefly, if a guardian is appointed and we're stripping rights away from an individual at this point, there's a guardian of the person. That's the individual who basically makes all healthcare decisions, residence decisions, all of those things. And you'll see on this list, they have the right basically to custody of the ward. And the ward is what we call an individual by statute who's been adjudicated incompetent. The guardian of the person decides where that person will live and what kind of care they'll receive. They can often decide what kind of medical treatment they're going to receive. Sometimes if they have to, and they may have to seek a court order for it, they might have to restrict folks who are visiting with the ward if there are individuals who are constantly interfering with the ward being taken care of. So the guardian of the person role is a very big role. And often when we get to the guardianship world, it's not uncommon for the Department of Social Services to get put in this position for a lot of folks who can't make decisions about their health care anymore. The guardian of the estate is the individual who is appointed to manage the ward's assets. So the guardian of the estate has to take possession of assets, handle legal actions, abandon assets if there's no value. We have to pay debts. Expend income and principal, but often we have to get a court order to spend principal. Guardians of the estate can employ professionals, so lawyers, CPAs, therapists, all of that. Sell assets. Often you have to have a court order to sell tangible assets. You always have to have a court order to sell real estate. Guardians of the estate can also use the ward's funds to support a spouse or minor children, or even maybe create a special needs trust. There's a lot that a guardian of the estate can do, but remember, if we get to the point that there's a guardian of the estate, that's the individual who manages the money, signs legal contracts, makes those decisions, and the individual who's been adjudicated incompetent cannot do that anymore. So less restrictive alternatives. Now we're getting to the real heart of it, right? Which is if we want to avoid guardianship and we want to come up with a different arrangement, what are those less restrictive alternatives? What can we do? So this is just a reminder of that definition, right? We have a definition now in North Carolina that says what a less restrictive alternative would be. I won't read it to you again. All right, so let's dive into some of these. A less restrictive alternative regarding finances. So the first one, which most of you probably are aware of, is a durable power of attorney. So this is a document where the principal, in this case maybe the resident, names an individual who will manage their financial or legal affairs when they get to the point that they cannot manage them for themselves. In order to sign a durable power of attorney, the individual needs to have contracting capacity. And if you really think about what a durable power of attorney will do, You're giving an individual the power to access your bank accounts, sell real estate, loan money out to other individuals, borrow money in your name. You're giving them the ability to file your tax returns, to continue charitable giving, right? It is a lot of power that you are giving to someone else. And in order to sign that document to give those other individuals those powers, you really need to understand what you're signing. And it's a really high capacity level. You need to understand it. It's a contract. It is a supportive decision-making document. So if you sign a power of attorney, it doesn't mean that the agent now takes over. Their job is to support the individual in making decisions for themselves and continuing to act for that individual when they can't anymore in the way the individual would have acted for him or herself. So if you've named a financial agent, the agent doesn't all of a sudden have the right to go to the facility administrators and say, you're no longer allowed to talk to my mother, I'm her agent, you have to talk to me. That's not how a durable power of attorney is supposed to work. Powers of attorney for finances can be limited. So often when I am drafting a durable power of attorney, I talk to the individual about lots of specific powers that they may or may not want to give their agent, right? Gifting assets away, for example, is a power that you need to be very well informed of before you just let someone have that power. As you all know, gifting assets away could significantly jeopardize someone's ability to qualify for long-term care benefits, either under the Special Assistance Program or Medicaid. And so if you're going to give an agent the ability to gift assets, it should be limited in some way. We talk about the ability to change beneficiary designations and things like that. Maybe you don't want the agent being able to loan money on your behalf, right? So a power of attorney should not just be a fill in the blank form or a checklist. It should be something that's very well thought through before an individual signs it. And I put here that abuse does happen. It's not uncommon for an agent to take advantage of their loved one who, they're supposed to be managing their money in their best interest. Any administrator of a facility has probably seen this a dozen times at least, where the power of attorney just doesn't use the money to pay the facility bill. And so the room and board continues to go unpaid and we have an outstanding balance and we have issues, right? In those situations, often a guardianship ends up happening, and it's because the agent under the power of attorney is abusing their power. It's also, though, not uncommon for an agent under a power of attorney to justify the things that they're doing. So I have seen situations where daughter serving as agent for mom uses mom's money to pay for them to go out to lunch once or twice a week because mom's always done that. It's just something she would have done. But then that spirals into paying for tires for the car because you use the car to take mom everywhere. And then daughter justifies that to, pay for a vacation that she needed for respite. It just spirals out of control. And so again, when you see abuse like that, that's when it pushes us in a direction of potentially needing a guardianship. Crystal, you got a question that came up?
Well, no, I just thought, unfortunately, we haven't had any questions yet, but I welcome everyone we have 64 attendees, so I'm hoping some will share some. I jotted a few down, but just thought maybe we could take a break here and pause. And I have some questions maybe that'll help stir the pot and get some going.
Yeah.
So one thing, I actually had this question yesterday. A lot of families, when addressed by the facility or by folks, say, hey, this might be a good time to consider guardianship because like your loved one we're kind of past the point where we feel like a power of attorney is going to really work because of their capacity, competency. Right. I know you said those are two different things, but capacity, I think, is what we're looking at. But a lot of people are worried about the cost. The lady that I talked to yesterday was told it was going to cost $4,000 or $5,000. And I was like, I don't believe so. It's usually just the court proceeding cost, right? At least here in North Carolina.
It depends on what type of guardian you need and how contested the proceedings will be. So, okay, if all you need is a guardian of the person, you just need someone who can make medical decisions. We have an individual, their only source of income is Social Security, and we'll talk about rep payees in a minute. And it's really just, we don't need anyone extra managing money. We just need someone who can make decisions about healthcare. Often folks can go to court without representation of an attorney and seek that type of guardianship. The problem is that folks don't always show up with all the evidence that they need. And then that's the roadblock that folks face in a guardianship proceeding is they fill out all the forms, they show up to court, and they don't actually have any evidence that a person is incompetent, right? And so it can be expensive if you need a lawyer to help you. And $4,000 to $5,000 for attorney's fees to handle a full guardianship is actually not really out of the realm of reasonableness at this point. If it is a contested proceeding, right, whether it's we're contesting it because the individual you want adjudicated incompetent says I'm not incompetent, or you have other family members or friends who say they're not incompetent, the costs skyrocket, right? If everyone agrees that someone is incompetent and needs a guardian, but we're fighting over who that guardian should be, that's where the costs increase again. So, when I'm working with individuals before they ever hit a point of guardianship, right? A lot of the counseling that I give when doing a power of attorney is we're trying to avoid the need for a guardianship. We're trying to name the best people possible to serve in these roles because guardianship can be very expensive.
Okay. That's helpful to know. So it can cost if there's any questions or finances involved.
Yeah. What I have told folks in the past, and if there are people who are participating who work for the Department of Social Services and Adult Protective Services, I'm so sorry, but it is a financial barrier. If you are truly worried about someone's ability to make decisions for themselves and they're an appropriate APS case, right? They're a danger to themselves. They are being financially exploited. They're neglecting, themselves or being neglected by their own caretaker. APS could get involved. They could do their own investigation if they substantiate, right, that this individual needs assistance and they need a guardian. APS could potentially file that action. I don't think people should turn to adult protective services to file the actions if they can do it themselves because, they've got a lot of cases themselves. The other issue with APS filing it is if it gets to the point that they're having to do it, then it may be less likely that a family member or friend gets appointed as the guardian, right? I know that our local adult protective services, if they think that there are appropriate individuals to serve as guardian, they're going to push that forward to the clerk and try and make that happen. And they do a really good job with that. But I've also worked with other counties where if APS gets involved, they're just going to take over. The counseling sessions I have with folks who are hesitant to take the step for guardianship because of financial reasons, then sometimes we have to turn to adult protective services for help.
Hi, can I speak up as an adult protective services supervisor? A great point, Jennifer. APS can absolutely get involved. I would say one thing I have noticed in my county in particular is a quick jump to calling APS because a bill isn't getting paid.
Yeah.
And unfortunately, we are not bill collectors. I encourage all facilities to reach out to families to try and collect money. Oftentimes we're finding families didn't realize they needed to do something with this money and it wasn't being spent. It's just sitting in an account, and it is taking up a lot of time on social services part to become essentially bill collectors.
Mm-hmm.
And in my county, at least, if a family reaches out to the clerk's office and lets them know they may not be able to pay the full filing fee, our clerk's office will do a reduced fee for those families. Not always, I don't know what their criteria is, but if they let them know, oftentimes they can do that. And just, word of caution, because APS is involved doesn't mean we will always file.
Yeah.
But most counties can take guardianship referrals, which may at times be a faster process. APS is going to go through an entire evaluation process, which is at a minimum 30 days, sometimes 45 if it's exploitation. And if we decide to file at that point, we're looking at least another 30 days to get a hearing date.
Yeah.
So sometimes a guardianship referral to a local DSS could be a faster alternative. Really fastest is filing on your own, but that is not always in the right way. It is, as a person, I could go and file, sure, but I do it on an almost daily basis. A common person, it is very daunting, but APS is not always the jump to, because it will take us sometimes, and then we get the calls, well, why aren't you doing it? Why aren't you doing it? And unfortunately, we have to follow a process as well.
Yeah. Heather, thank you for sharing that. And I've gotten that feedback from our local APS also, that often they get the calls from the facilities and they're not debt collectors, and there may be faster ways to resolve the issue. And, I will say too, for those of you who think that filing it on your own can be daunting, it can, but a lot of the guardianship filings, there are already forms available. Right. So most clerks have packets, and you could pick up the packet and review it and fill in the forms yourself. You're not having to draft something from scratch. And the whole purpose of those forms that are put out by our Administrative Office of Courts is to make access to our court system available to everybody. You don't always have to have a lawyer there with you. The clerk's office cannot give you legal advice, but they can make sure you have the right forms and that you're getting them filed. And then the guardian ad litem, who is appointed in these proceedings to represent the individual, often they can be incredibly helpful too in guiding the process and getting the medical evidence that's needed and all of that. Guardianship just gets much more expensive when it's contested in some way, when there are a lot of people fighting.
Jennifer, thank you so much. That was very helpful. And yes, I would say APS probably gets shifted a lot of cases when people don't know what to do, right? But it's not always the most efficient. So I understand. The here in the chat, we'll take this last one.
Yep.
Can you explain the difference between a most form, which I know a lot of our nursing facilities use now, medical order for scope of treatment,
Yep.
and I guess the difference of having a medical power of attorney, which I think most of the time we consider healthcare power of attorney, if a person is living in a long-term facility?
Yeah, so a healthcare power of attorney and the most, medical order for scope of treatment, two different documents. A most is done with a healthcare professional. If you've seen that bright pink piece of paper, I often call it like an advanced directive on steroids, because it gives the individual the opportunity to have really in-depth conversations with their healthcare providers about what kind of treatments they want and care that they want. A healthcare power of attorney is done with a lawyer or on your own if you pull your own forms, right? And it is naming an agent to make medical decisions. An agent named under a healthcare power of attorney can work with healthcare providers to fill out a most form for an individual, but they work together. If you have a most form, though, it is a great guide to your healthcare agent who you've named when they're trying to make decisions for you about your healthcare, but they don't know what you would have wanted, right? If you've done this most form with your doctors, you've put on paper a lot of the things you would want regarding your healthcare, so they can work really well together.
Right, one almost guides the other, or
Exactly.
works in combination.
Yeah.
All right, well, I do have two more questions in the chat, but maybe if you want to move on for another maybe 15 minutes, and then we'll address these as well.
Okay. Well, so we've talked about the durable power of attorney, naming someone to manage financial or legal affairs. Another less restrictive alternative in managing finances would be a Social Security representative payee. So a representative payee, or a rep payee as we call it, is appointed directly by the Social Security Administration. Individuals serve as rep payees often, so parents for their own children, or children for their aging parents. We have companies that serve in this role. We have a company called Benefits Management in our area who often serve as a rep payee for Social Security funds. Facilities can serve as rep payee for Social Security funds. If you have an individual that the only source of income they have, and they are living on a fixed income, meaning money comes in and it goes right back out to pay bills, A rep payee may be absolutely all that you need in terms of managing their finances. It does not require the consent of the Social Security recipient, and it doesn't require the appointment of a guardian. So you do not have to go through an adjudication of incompetence process. Someone who has a rep payee could ask Social Security to name someone. They can fill out the forms approving it, or someone can go apply to be rep payee for somebody else, and then they just have to meet Social Security's requirements in proving that that individual needs assistance in managing their check. The great thing about a rep payee process is it will allow you to open up a representative payee bank account with a bank. You don't have to have a power of attorney. Now, Social Security does require their own annual reporting, and so they are supposed to, it doesn't always happen, but they're supposed to send out a report form to the rep payee annually, and that rep payee fills in the boxes and information on that form that says, this year I received $14,000 for this individual. I spent $12,000 on room and board and the rest of it on food, right? It gives you the ability to do that, but none of that is ever before a clerk of court. There are no filing fees to become a rep payee, so you don't have to worry about that cost. It's just a little bit slow. I would say in our area, when I apply to be rep payee, we're looking at about a 2-month process before I finally get my approval and the check starts coming to me to serve in that role. But if you have an individual who just needs help in managing that check, then the rep payee may be all you need. And that is used often by facilities, especially for an individual who's in the facility on Medicaid. It makes a whole lot of sense for the facility to be representative payee, for the Social Security check to come directly to the facility to go towards that patient monthly liability amount for the Medicaid recipient. And we don't have to worry about a delay in the facility getting paid. We don't have to worry about outstanding balances increasing. We don't have to worry about family members or friends exploiting the individual and stealing their money. So it could be a really good solution and a less restrictive alternative to guardianship. There is a similar process through the Veterans Administration for a VA fiduciary. The VA fiduciary is appointed by the VA. It does not have to be a guardian, and you do not have to have the individual adjudicated incompetent by our clerk of court. The VA does their own investigation to determine if an individual lacks the capacity to manage their own VA benefit. So they have field officers and offices, and they send them out to actually come see the person, to talk to people, to interview. The process can take quite a bit of time, but it is an alternative, again, from having to go through a guardianship action. So if you have an individual where they're receiving Social Security and a VA benefit, you may be in a position that someone can become a fiduciary for both of those sources of income without ever having to do a guardianship action or having a power of attorney. Again, a VA fiduciary, like a representative payee, we don't need the consent of the recipient. But it's been my experience with the VA that they really either want consent from the recipient or they really want proof that the individual really lacks the ability to manage their own check. They do not take it lightly. And we've had cases where an individual's been adjudicated incompetent, and it actually took us several tries to become VA fiduciary because the VA didn't agree with the incompetency ruling. So, you know, it can be a process, but still worth it if you can do that over a guardianship action. There's some other less restrictive alternatives regarding finances. There's a lot of trust planning that can be done, revocable trusts where the individual has set up the trust that can be amended or revoked at any time if they have capacity to do so. Revocable trusts can own assets. So if you have an individual in the facility or in the community, their home can be put in the trust, their checking accounts can be put in there, and then the trustee of that trust manages those assets. A guardianship does not allow a guardian to actually access the trust. A guardian doesn't take over as trustee. It may be an action that has to be taken legally to have a new trustee appointed. But it happens where an individual may need a guardian appointed for one thing, But they may not need a guardian of the estate to manage money because all their assets are sitting in a revocable trust, and the trustee would manage it. Now, the capacity to sign a revocable trust is fairly high. I mean, you need testamentary capacity, but you also need a higher capacity level because trusts are much more complex. So this less restrictive alternative may not work for an individual who has diminished capacity. It will really depend on where they are on that spectrum. But if they already have a revocable trust, but they just never funded it, right? Well, maybe we can take some steps to put their assets in that trust, and now the trustee can manage it without having to go the guardianship route. Irrevocable trusts cannot be revoked or amended after they're set up without meeting some other criteria, either getting consent from all beneficiaries and the grantor or going to court and getting a court order. But again, this might be something where we turn to the trustee under this document to manage assets instead of asking the court to appoint a guardian. Because remember, a guardianship doesn't resolve all issues. So if the issue is trying to manage the trust account or the assets in the trust, appointing the guardian doesn't immediately resolve that because the guardian doesn't have the authority to take those trust assets. There are also special needs trusts that can be set up. This probably won't work for anyone 65 or older living in a facility, but if you have someone younger living in a facility with a disability, setting up a special needs trust and funding that with their assets and having the trustee manage it, again, might be a less restrictive alternative than having a guardian appointed to manage assets and report to the court. Crystal, did you want to jump in with any questions before I move to the next?
Well, my camera's having a hard time coming on, but there we go. Yeah, I did get a lot of questions in. Do you want to go ahead and take a few?
Sure, yeah.
Okay. Well, Patricia asked first if you could just discuss if someone wanted to change their power of attorney, how does one do that?
As long as the individual has capacity to execute a new one, then they can make a change. I don't typically suggest amending a power of attorney. I would suggest revoking an old one and doing a new one. There are ways to remove agents under a document and all of those things. I just think it's cleaner to do a new one. But as long as they have capacity to contract, to understand that document, they can do a new one. They're not bound by it forever.
So I also, I think a lot of, I guess the question, I'm sorry, I'm trying to look and read at the same time. My poor brain can only handle a little bit. That poses a question I actually wrote down earlier. I guess, how does one find what kind of agent, or if someone has an agent, if you're just a resident gets dropped at your facility and you have no idea, where does one start to look of if the power of attorney changed, if they have a guardian? How does one find that information quickly?
Like who the agent is, or the individual trying to find someone to help them?
Who the agent is.
Yeah, that's a little more difficult, right? I recently got appointed on a guardianship case, and an attorney is now involved with the family, and they located a power of attorney after it was all said and done, which is incredibly frustrating for the whole family, right? Because if they had known the power of attorney existed, I would not be in the picture. When it comes to an individual, if they're able to communicate in any way, hopefully they can share that they've done these documents before. Maybe they can remember an attorney that they worked with, and a phone call might be made to the lawyer to see if they still have copies of the documents or if they're holding originals. Financial powers of attorney prior to 2018, a lot of them were recorded with the local county register of deeds. So that might be a place to start for powers of attorney that were done prior to 2018. We adopted the Uniform Power of Attorney Act 2018, and now you do not have to record a power of attorney unless you're trying to sell real estate as an agent. So it's less of a resource now. But it is not an easy process to try and find that stuff, especially if someone, was put in the hospital, moved from the hospital to a facility. Maybe they rented an apartment and all their stuff might have been moved out. But it's a fact-finding mission. On the front end of all this, what elder law attorneys, estate planning attorneys are always counseling folks to do is when you do this kind of planning, People need to know about it and know where you store your documents, right? If they don't know it ever existed, they can't use it later. It doesn't necessarily mean that if you do a power of attorney today that you need to give copies to everybody, but they should know that you did them, and that if they need them, they're located in this drawer or at this bank at the safe deposit box or something like that.
Thank you. The next one is from Kim. I'm going to try to read it verbatim. If the durable power of attorney is in effect and the patient resident also have simultaneous ability to act on their own behalf, including overriding a decision made by the person with the power of attorney.
I get that. If you have a resident who has capacity to make their own decisions, their decision is first and foremost. If they have named an agent under a power of attorney and that agent tries to make a different decision than the individual who they're trying to override, right? They come first. And if they are unhappy with the agent and how they're acting or the decisions that they're making, their next step is to revoke the document and potentially ask for an accounting of anything they've been doing. So,
no, I was just thinking, I know she said in effect, I'm wondering if she's referring to, I know I've been told a lot when I deal with these cases where it gets a little gray, is there's kind of a switch button, but it's buried within that power of attorney document of when the rights of that power of attorney are turned on.
So,
right?
Yes, that's called a springing power of attorney, and they are not favored anymore by law. So most lawyers, when they draft a power of attorney for finances, it's effective the moment it is signed. So if mom signs a power of attorney and then goes on a cruise and she forgot to pay her power bill, daughter named as her agent can use that power of attorney to contact the power company and pay the bill. When mom gets back, right, mom's still in charge of her own affairs. Thanks so much for your help, daughter. And if daughter keeps trying to take over and says, Mom, I'm just going to manage your checkbook from now on, and mom says, no, you're not, that's when, we revoke the document and say, sorry, you're out now. Healthcare is a bit different. A healthcare power of attorney is effective if an attending physician determines that the individual lacks the ability to make an informed decision. So if you have an individual where all the care team, the providers, the doctors have all said this individual has no idea what's going on, they lack capacity to make the decisions for themselves, the agent is the one making those decisions. The question is, do we ever find a time where that individual has regained the capacity, right? If you're talking about someone with dementia who has fluid capacity, well, if they go to the doctor in the morning, they should be able probably to make a lot of decisions for themselves. But if you set their doctor's appointment at 3:30 in the afternoon, they might not understand anymore. That is why when you talk about powers of attorney, they're supposed to be supportive decision-making documents. The whole point is that the agent who has been named is supporting the individual in their own choices they can, right? So if you have an individual who really wants to maintain their own checkbook, but they struggle making sure they don't overdraw the account, well, the agent's supposed to step in and help find ways where that person can still manage their checkbook, but prevent overdrawing the account, which might mean setting up a different type of account, or setting up some sort of parameters on the account where we can't overdraw, or setting up auto payments where we don't really need to write checks anymore. Does that make sense?
It does. I mean, it's essentially, they're still a supportive. They don't just take it over, which I think some people are going to do that anyway because of personality. Yeah. But generally, especially because of the way LRA is coming out, it's to promote this ability to have like sharing of responsibilities and decision making.
And I imagine most folks who are attending today feel a very strong sense of making sure that an individual maintains as much autonomy as possible to make their own decisions, right? That's why we work with seniors. That's why we've all chosen the field that we're in. You should be able to make your own decisions, even bad ones, right? If you have the ability to understand consequences of those decisions. When you have an individual where that starts being more difficult, we just still want those advocates and those supports to help you continue to do the things for yourself that you can, and pick up the pieces on the side and pick up the extra that maybe you can't handle anymore. When we swap over to guardianship, that ends. Guardian's in charge. Any other questions?
I have two more if we want to. Do you want to go ahead and finish your slide set? Or do you want to answer these two?
You can go ahead and pass me those and then we'll move on to the next ones.
Okay. Oh, somebody must have typed something new. I lost my spot. Okay, here we go. Is there a need? I think we kind of discussed this earlier, but just kind of circling back around. Is there a need to have a healthcare power of attorney if a most form is signed?
Maybe, right? I mean, it depends on, does that most form cover everything? And are the healthcare providers comfortable following that most form if the patient that they're treating no longer has the ability to provide informed consent? I am going to cover a slide in a minute about North Carolina's basically our surrogate statute that'll cover a little bit more of that. But I always think it's a good idea to have the healthcare power of attorney if the person's capable of signing one, for those what if moments where we need someone to step in and make a decision that maybe other forms haven't covered.
Gotcha. And I mean, the most form isn't typically going to always be filled out unless you're in a facility, right? Those seem to be very preferred in facilities. I don't see, maybe I'm wrong. Are they used in the community a lot?
Some doctors, especially when they work with a lot of seniors or they work with a lot of patients who have been diagnosed with terminal illnesses or other types of illnesses where they really need to have a longer plan of care. I encourage my clients to bring up the most form with their doctors, because a lot of my clients, their doctors don't bring it up. So, but it's not uncommon for folks to do even when they don't live in a facility.
So I have, and this will piggyback and then we'll move on. Oh, I lost it again. Okay. The question, I'm going to try to rephrase it, but basically it was, which is more preferred, the most form or a DNR? And then a secondary question was, what is the medical professional's responsibility in response to those forms?
Okay. So a
Especially,
DNR and a most. Go ahead.
I'm sorry. I found the question. It says, please speak specifically to those people who are still living in their own home as well.
For the DNR and the most and all of those forms. Okay, so a DNR and a most are two very different forms. And folks should talk to their doctors about both of them. What I tell folks is, healthcare power of attorney, you do with your lawyer. Some folks do them on their own. Some folks do it through the hospice program that has the last 5 wishes form. The most order you do with your doctor, and a DNR you do with your doctor. A DNR is a do not resuscitate form, meaning if you code at home and emergency services show up, if they see that DNR in place, they're supposed to leave you alone, right? They don't try and resuscitate you. The most order is typically used when we're talking about longevity of care and the quality versus quantity of life, right? When we're talking about, I've been diagnosed with this illness and this is the treatment plan. And if we get to the point that this isn't working, this is the type of medication I want to try, or this is the treatment I want to try. It forces a patient to have much more in-depth conversation with their healthcare providers about what they would want. What you want is for a most form, a DNR if you have one, and your healthcare power of attorney to complement each other, not contradict each other. So you do not want to have a healthcare directive with a living will that says you want maximum treatment if you end up on life support, but then also do a DNR with your doctor, right? Because that contradicts itself. How do we know which one to follow? Now, the rule of thumb is we follow whichever was executed last, but it still causes a lot of confusion for folks. Mm-hmm. Doctors, I have a colleague who serves on the ethics committee of a hospital, and he does a lot of presentations with medical students and doctors about how to make medical decisions with or for a patient. And the consistent feedback I get from him is that they look at every single document. They look at all of them, and they try and piece together the ultimate wishes of the patient. And they can all work really well together if they complement each other. And again, If they don't complement each other, it just causes a whole lot more confusion on the back end when doctors are trying to decide what to do or try and counsel families on what to do.
Yeah, I was, I mean, ultimately, a lot of this legal, when I think about it, it's at the interpretation of the person who winds up having to make that decision. So you want to make it as clear as possible, because the human on the other side may not know you.
That's right. Yeah. I mean, I think that's a really great way to put it, is when you're dealing with individuals who are having to review these legal documents, especially when they're not lawyers, right? The cleaner we can make it, the better.
So I want you to, I'll let you go ahead and finish up your slide. I see you have just a few more, and then we'll take the remaining of the questions. I'm going to try to write them down while you're doing that.
Okay. All right. So we've already touched on a lot of this, but we're going to talk now about less restrictive alternatives for healthcare decisions. So we've talked a lot about the healthcare power of attorney, and that's where you name an agent who can make medical decisions for you if you cannot make them for yourself. And there are actual legal standards about informed consent that doctors follow. And the statutory definition is here, but we measure whether a patient's choice is the result of an informed consent. Informed consent is a reasonable person, from the information provided by the healthcare provider under the circumstances, would have a general understanding of the procedures or treatments and of the usual and most frequent risks and hazards inherent in the proposed procedures or treatments. And that is why, when it comes to a healthcare power of attorney, it only becomes truly effective if the attending physician determines that the person they're caring for cannot give informed consent. That's incredibly important, right? If a doctor is working with a patient and that patient generally understands the decisions that need to be made and the risks that come with those decisions, that individual makes their own decision about their healthcare. We do not get the healthcare agent involved. And I find very often for folks who are living in a facility that piece gets ignored. Right? They're in a facility, they need nursing care, therefore they don't have the ability to make any decisions, and the facilities often just turn to the healthcare agent. But we need to make sure that we put forth an effort to make sure that resident is being consented with first, right? It's their healthcare, it's their needs. A lot of facilities I work with are wonderful when they have their care team meetings, that they have those care team meetings with the resident and the healthcare agent. But it's important that resident be a part of it if they can be, right? So even if they may not understand every decision that needs to be made, getting some input from them is incredibly important. Don't just assume because they're in a facility they lack capacity to make a decision. Don't just assume because there's a healthcare agent who has taken on the responsibility of making those decisions that the resident can't make them for themselves. It should be, again, a supportive decision-making document. And there's also advanced directives, that the statutory phrase advanced directive for a natural death. Often folks refer to that as a living will. And that is where you make decisions about end-of-life care, whether you want machines breathing for you or tubes and IVs giving you nutrition and hydration. I get a lot of phone calls from folks where their loved ones are in the facility and they're on life-prolonging measures and they cannot find an advanced directive and they don't know what to do. And sometimes I get the call and they say, well, we need to get a guardianship, so that we can make this decision. That's not accurate, and I'm going to talk about those statutes in a minute. But an advanced directive can be incredibly helpful and quite a gift to family. Or a gift to a future appointed guardian. So I know that our local DSS, when they're appointed as guardian of the person, they look for these advanced directives, because if they get put in the position as a guardian of the person needing to make an end-of-life decision, it's a whole lot easier to make those choices if the individual already made it for themselves, right? And they'll honor that because we have to. In order to sign an advanced directive, you just need to be in a position that you can give informed consent. For these medical documents, the whole capacity level to sign them is, are you in a position right now that if you had to have a discussion with your doctors about your health care, you would generally understand that? That might be a pretty low capacity threshold for folks. So there are a lot of folks who might be able to sign a healthcare power of attorney, but not necessarily sign a durable financial power of attorney. So keep that in mind as well when you're talking about less restrictive alternatives with folks. So North Carolina has basically a surrogate statute that doctors can turn to when it comes to needing someone to make healthcare decisions or end-of-life decisions. So, first we have to look to see, was there anyone appointed by a court or by the patient? So that might be the guardian of the person. It might be a healthcare agent, might be a legal agent under a durable power of attorney that has healthcare powers. But there are also default statutes, and that is if you have an individual where healthcare decisions need to be made or end-of-life decisions need to be made, if they have a spouse who is living incompetent, they can step in and make those decisions without a guardianship. A majority of reasonably available parents and children, as long as they're over 18, siblings over 18, or an individual, this is really interesting, right? An individual who has a relationship with the patient and acts in good faith, which a lot of doctors are not comfortable with. So my colleague who gives these presentations, he said that gives doctors a little bit of heartburn, right? They are not comfortable with just letting the friend who's there, who claims they're friends, right, and they are really close, make decisions. But, right, who is better equipped to make a healthcare decision for the individual, right? Is it a disinterested public agent appointed as a guardian of the person who has never met this individual or had conversations with them about what they want? Or could it be the spouse of that individual, and they've been married for 55 years? And doctors, Crystal pointed to this, the individuals who are reading the documents or the individuals who are going to be impacted by the decisions that need to be made, right? Those are the individuals who are going to make this decision. So if you have someone in the facility and a decision needs to be made about a new prescription medication, right? The facility could turn to the family to approve of that without actually having the healthcare documents in place. But I can completely understand how the legal counsel of the facility might say, absolutely not. We got to see a healthcare power of attorney or we want a guardian. And it's all about risk management, right? We don't want anyone to be afraid they're going to get in trouble later because they're just trying to do the best they can for an individual. But again, guardianship doesn't solve all problems. And so we should evaluate whether or not we can utilize this statute, especially with the default appointments, in order to make a medical decision for someone before we file that action with the clerk of court for an adjudication of incompetence. Some additional, less restrictive alternatives. There is this concept of supportive decision-making, and many states have actually adopted statutes about supportive decision-making. The standard definition of that is that it is a series of relationships and practices, arrangements, and agreements designed to assist an individual in communicating and making decisions for themselves. It could be formal, it could be informal. Again, it's going to be up to a facility or an institution, right, working with these supportive folks and making decisions for an individual. The supportive decision-making concept is a wonderful concept for individuals who are young adults with disabilities. Just because someone has Down syndrome or they have autism doesn't mean that they should be adjudicated incompetent and stripped of the ability to make decisions for themselves. This supportive decision-making concept is them surrounding themselves with individuals that they trust, and all those individuals work together to help that person make the best decisions for themselves that they can. And so that can be a great way of avoiding guardianship if you have a really great group that no one is concerned that bad decisions are being made or exploitation is happening. We're just trying to help this individual make their decisions. And then finally, I just want to point out that we have a fairly new statute that allows the clerk of court to appoint a special fiduciary or a temporary guardian. You still have to have an adjudication of incompetence, but we might be able to at least avoid the need to have a permanent guardian put in place. So a lot of the less restrictive alternatives that I talked about setting up maybe a special needs trust or funding a revocable trust that's already been established, just nothing ever went into it. We might still need a clerk of court to appoint someone to take those steps. We call them single transactions proceedings. So, I've had situations where the court did adjudicate someone incompetent, but I was appointed as a special fiduciary. My only job was to go to the bank and have a check made payable to the facility so the individual could be placed there, and we were privately paying to get them in. It closed the account out, and then I'm not needed anymore because the facility will become representative payee, and maybe there was already a healthcare agent under power of attorney. And temporary guardians, it's kind of similar, but it might be a longer process than the special fiduciary role. Again, they're fairly new, and not all clerks in our state have seen these. There aren't a whole lot of fill in the blank forms for these types of appointments, so it really takes some creativity from the attorneys seeking them. But it does put us in a position that we don't have to have a guardian there making every decision for every single thing. We can make all of these different pieces work together in order to avoid the guardianship action. So just kind of a wrap up of guardians versus other surrogates. This might be the one statute that can consolidate it all together. But we have the guardian. They usually have plenary power. Sometimes it can be limited. But most of the time, in order for the guardian to make a lot of decisions, even though they can make almost all of them, they may often seek a court order to approve it. We have a healthcare agent, again, broad plenary powers in the document to make healthcare decisions, but it is perpetually springing, right? Meaning if the person has capacity to make a decision, they make their own decision. When they don't, they don't. But we should constantly be evaluating that before we just override someone's ability to make their healthcare decisions. A legal agent, someone named under a durable power of attorney, but their powers can also be limited depending on what the document says. We have the representative payee for Social Security benefits, a wonderful way to be able to access someone's income if it's Social Security, but just keep in mind it's only limited to Social Security benefits. So if we have a North Carolina state pension or a railroad pension, or if we have a benefit coming from another state, the rep payee process through Social Security is not going to resolve that issue. But this could be a really great way to stay out of the guardianship world if the only income is Social Security. The VA fiduciary role, again, the VA appoints that person, but it is only to manage veterans' benefits. It's not going to give someone the ability to manage anything else that someone has. The trustee role, of being able to manage assets in the trust, but bound by the terms of that document. And then wrapping up with the supportive decision-making, right? Having a strong network of individuals who can work together to support someone in making their own decisions about healthcare and finances. All right. So, Crystal, what other questions did we end up with?
Yeah, we have a few. Thank you. And I'm going to jump ahead of all of them and frogger them. Have that ability because I'm host. I just want to go back over this last slide. And so that, the point, it sounds like that you guys are really trying to make sure that people are aware that guardianship isn't the only way to provide someone support when they no longer have capacity or not quite able to manage everything. But, as a person who's out there a lot with residents who don't have a great support system, guardianship is still needed for some people, I feel like.
Yeah.
But you're saying that now the rules are saying that you actually have to prove that you've tried those prior to even applying for guardianship at this point.
Well, the rule is you have to have considered them, right? So if you have an individual who is in a facility and they can't even communicate anymore, right? The statute's not saying, well, you got to get them to at least try to sign a POA. What the statute's saying is, did you consider it first, right? So when you file a petition to adjudicate someone incompetent, on your petition, you're going to state the nature of the person's disability and why they can't make decisions. And then you're going to state, we evaluated being able to do a financial power of attorney, but they lack capacity to sign it. We evaluated doing a healthcare power of attorney. They lacked capacity to sign it. And so the court just needs to see that everyone, especially the petitioner, right, before just jumping into guardianship, has evaluated the potential for any other options. Because that's always been the problem, is we end up in a guardianship action, but nobody actually look to see were there other things we could have done before we got here. And usually once you get there, it's kind of hard to stop the train once it's moving.
Thank you. So we'll move to, I believe Kim had a question about the fiduciary. She said you've used the, you've referred to the word fiduciary. What is the qualification for fiduciary? Just you can name yourself there, or is there some type of qualification that makes you one fiduciary?
So fiduciary is a term that encompasses all roles of someone who makes decisions for somebody else, but they have to put that person's needs before their own. So financial agents under a power of attorney, they are a fiduciary. A healthcare agent under a healthcare power of attorney is a fiduciary. A rep payee is a fiduciary. So all of these roles, whether an individual appoints you in that role and you're a fiduciary, or Social Security or the VA appoint you, you're a fiduciary. And then if the court appoints a guardian, those guardians are fiduciaries. And the whole point is when you get named into a position to make decisions for someone else, their needs always come before your own, right? So when you talk about that daughter who is managing mom's assets and she lives with mom and she doesn't work and mom's paycheck is paying, or income from Social Security is paying for everything. And now mom has to go to a facility. Well, how does daughter continue to live in the home, right? She has to put mom's needs first as the fiduciary under that power of attorney. So she has to pay mom's room and board. That's how it works. And that's
But
detriment.
it is a legal term, though. When you use the word fiduciary, it means you are a legal representative. You're not just saying, well, I take care of mom's, I write her checks, or my name's on her checking account. It's, I have legal power to act on their behalf in such and such capacity.
Well, I will say this, fiduciary role, there is a legal definition, but the confidential relationship, there's a definition of that too, because there are individuals who aren't legally named in anything, but they've taken on a role, right, of doing something. And so we do a lot of litigation, right? And we sue folks for breach of fiduciary duty. It doesn't necessarily mean that they were serving under a power of attorney. I mean, we've had individuals where they were the caregiver in the home, right? They were paid to do a service and they helped the person manage their checkbook, right? That person trusted them to help them pay their bills. And then we find out later they were stealing from them. Well, there was a confidential relationship there. The individual was trusted to help. That's a fiduciary duty that they have now breached. So we have legal fiduciary roles, but then we also have this confidential relationship fiduciary role. So that supportive decision-making group that I talked about, all of those things could be informal, right? It could literally be a neighborhood and they all look out for this one person and they've come up with this plan, but they may not be named legally in anything. But if they've taken on this role of being one of those helpers in this supportive decision-making setup, and then they do something wrong or bad, that's a fiduciary duty that they've breached. That's an argument I would make if, I were suing them later.
Okay. Thank you. Natalie asks, what if the person who has been assigned to POA no longer wants to be the person's power of attorney due to family dynamics?
So I give this counseling session a lot to folks. When you have an agent under any type of document who wants to resign, they don't want to do it anymore. If they have actually served in the role, then they have to do a resignation. It is appropriate, to resign. If they've never actually served in the role, then it's really renouncing their right? Mom's become incapacitated. I know I'm named first in the power of attorney, but I don't want to do it. So I renounce, brother, you take over. But if I've already been managing things and mom becomes incapacitated and no one will leave me alone, I can't just walk away, right? So there have been times where the individual who wants to resign, if there's no one named as a backup to them, I have encouraged them, go get the guardianship and ask for someone else to be appointed. I've had a situation where APS had to get involved because there was no one else. The individual lived out of state. It was going to be very difficult for them to get involved. And the person who we needed adjudicated and competent was being exploited, going and getting those green dot cards and all those things. And the out-of-state agent just could not do their job to protect them. So, you can't walk away. You can't just drop it all down and walk away unless you notify someone. Now, if I've been acting for mom and she's perfectly capable of making her own decisions, she just didn't want to do it anymore, then I can simply just go to her and resign, right? And I can just give her a formal letter that says, hey, mom, I'm not doing it anymore. And that's okay. It's just you got to put them on notice.
Okay. The next question is, if you have a healthcare power of attorney for someone who has agreed to let you have this authority, is it not binding because the doctor has not considered them incompetent?
Well, so if the end, so let's talk about a situation. The individual has a doctor's appointment and they ask for the agent to come with them, but that individual has capacity to make their own decisions. Then they have to invite this person to be a part of the appointment. They have to bring them into the fold. And the doctor should still be talking to this individual. This individual makes their own decisions, but if they don't want to make the decision alone, they can turn to their agent and say, what do you think? Help me decide. But ultimately, the patient makes the decision. The doctor should always talk to the patient. Patient decides, not turn to the agent and say, well, she's refused to make a decision. She just wants you to do it. You do it, right? Because you're not getting informed consent from your patient. I hope that's clear. I mean, I think doctors take that very seriously. It's not uncommon for, a parent to have their kid come with them to all their doctor's appointments and to turn to their kid and say, what do you think I should do? And they make all those decisions together. But it just should never be the parent's fully capable of making decisions, but they're not even there as part of the process.
Okay. I think the last question that we got was from Rochelle. She's a fellow ombudsman. She was asking, what is the best practice for empowering communities when the family members are giving pushback because they are the power or guardian for the resident?
Does she mean they're getting pushback from the facility and trying to make decisions for the resident?
Rochelle, you want to
Yeah,
provide a
Crystal,
little?
thank you. So
Mhm.
one of the things that I have found, Jennifer, is that there's a power of attorney in place, and the power of attorney feels that they are the end all to be all, like you said before, and they want to continue to make decisions for the individual. However, the individual still has capacity. They still have the ability to say, I want this or I don't want this, but POAs will use that as a way to bully the community and say, this is what I want. You have to do what I say because I'm that, I'm my loved one's POA. So it's very hard to empower communities to say, no, you can say no and not feel as though they're going to be cited or have any kind of pushback. So, can you speak on that?
Yeah, I mean, I would say that what the community should be doing is always thinking about, who can sue me later, right? If the individual who is the resident has full capacity to make decisions for themselves, continue to push back against that agent. And you might encourage the resident, right, to seek legal counsel about potentially revoking that document if the agent they've named continuously tries to override their decisions. We need to empower the residents, right, to make their own decisions. And that's where, the communities can turn to the ombudsman, right? And the ombudsman can connect that resident with an elder law attorney. And we can have some counseling sessions and some coaching about, what rights do they really maintain? And I think the hardest part that I see for individuals who are in facilities, quite frankly, when they have an overbearing agent, is they're so afraid of standing up for themselves because they don't want to be abandoned by the one person who's still in their life, right? And I know you've all seen that. Well, if I tell my daughter no, she's going to stop coming to see me, right? It is just such a hard thing to work through with an individual. But if they have capacity to make decisions for themselves, they have to advocate for themselves too. So the communities continue to do what you're doing, work with your resident. It is your resident who should be taking up the fight with the agent to say, you're not making decisions I want you to make. You're not making decisions I would make for myself, and I'm going to revoke the document. Until that person is ready, willing, and able to advocate for themselves, it's just always going to be a difficult position, and you're always going to deal with that fight. Now, Communities, if you have a lawyer, right, that represents the community, you might talk to them about coming up with some policies and procedures of keeping documentation showing what the resident wants and their ability to make that decision and the pushback you're getting from the agent. So that in the future, if the agent tries any type of legal action to say you weren't listening to them, right, you should have some sort of documented file to show that your resident had they had the capacity to make their own decision. And that's who you were listening to, because that's who you're supposed to listen to. So I'd encourage you, again, if you have legal counsel, and if you don't, find legal counsel who might be able to help you figure out what policies and procedures you can come up with to document these things to protect yourselves in the future. How are we doing?
Good. We really have 3 minutes. I have one more question in the docket, and I need to close up. But the person's trying to get a question about. Let's see if I can read it in a way that will help. If you have a healthcare power of attorney for someone, and it was done without the doctor stating that that person can't make decisions, that they're not incompetent, is the healthcare power of attorney still a binding agreement? I guess, meaning like, and correct me if I'm wrong if the person's saying this question. I guess if you get the healthcare power of attorney, you get it witnessed, and that person says, yes, I'm going to be your agent. And the person said, yes, I want you to be my agent to help me when I can't make some of these medical decisions on my own. That person is not necessarily deemed competent or incompetent at the point of that signature. Is it still does it still work once that person does become incompetent? I hope I'm saying this right for that person.
Yeah. So for powers of attorney, they should be signed, whether it's financial or healthcare, at a time the person has capacity to sign it, right? Healthcare powers of attorney have to be witnessed by 2 witnesses and notarized. A durable power of attorney for finances has to be notarized. The presumption is that if it's been witnessed and notarized, the individual had the capacity to sign it, right? If in the future that person becomes incapacitated, it does not make those documents invalid. They continue to be valid. The question is, if someone has been, what you should know is if someone's been adjudicated incompetent by a clerk of court, and then they go sign a financial power of attorney, that's not valid, right? Because we have a court that says they didn't have capacity to do so. But if you have a healthcare power of attorney and it was executed appropriately, meaning it has those witnesses and that notary in the state of North Carolina, then you're allowed to honor it. It's not and there are usually protections written in the document, and we do have protections in our statutes for healthcare powers of attorney for healthcare providers. If you are acting in good faith when you are honoring that healthcare power of attorney and working with that agent, you are protected. But if you have any inkling that the individual acting as agent shouldn't be acting, or if they're making really bad decisions, you have a duty to report that somewhere, right? So if you have a healthcare agent and they're going completely against everything that the doctors and the providers are recommending, and they're doing things that are endangering that individual, that might be an APS report, right? That might be something that really should be investigated at that point.
Thank you, Jennifer. So lots of good questions. So people started really sending them in at the end, but I appreciate your expertise and time today and sharing them with us. For everyone listening, we did record this session, and we're going to post the webinar, hopefully, on the PTRC YouTube at a later time. Don't forget, this is only the first webinar, so you want to tune back in to less restrictive alternatives, or the second part of our webinar series on October 4th. A confirmation email will be coming just to remind you. And with that, I'll say happy Friday and enjoy your weekend.